So friends, here's a good news story as we roll into the holiday weekend. Even after that idiotic Supreme Court ruling, you know the one, no nationwide injunctions for you, American people, even if Donald Trump violates your constitutional rights. Well, guess what, friends? Federal court judges are still pushing back, still ruling against, still rejecting Donald Trump's abusive, corrupt, and lawless schemes. Let's talk about that, because justice matters. Hey all, Glenn Kirshner here. So friends, first, let me wish you an early happy Independence Day. And yes, we will be talking about the meaning, the significance of Independence Day as it applies to 2025 America. But first, here is a vivid example of why I continue to say that the federal judiciary is holding strong. They remain a bulwark. They remain a firewall against Donald Trump's autocracy. Here is some new reporting from Politico. Headline: Judges are finding workarounds to Trump's so-called big Supreme Court win. And that article begins, if the Supreme Court's near ban on nationwide injunctions was the earth-shattering victory President Donald Trump claimed, no one seems to have told his courtroom opponents, or, for that matter, the federal court judges. My editorial addition. While the absence of that tool, a ban on nationwide injunctions, is clearly a sea change for the judiciary, early results indicate that judges see other paths to impose sweeping restrictions on government, Trump, actions they deem unlawful. And those options remain viable in many major pending lawsuits against the Trump administration. Since the High Court's ruling last Friday, U.S. District Judge Randolph Moss issued an extraordinary rejection of the president's efforts to ban asylum for most southern border crossers, a ruling with nationwide effect. Moss, an Obama appointee, emphasized that his decision was not one of the now verboten injunctions. Instead, it relied on two alternative routes the Supreme Court acknowledged remained available for those challenging Trump's policies: class actions, which allow large groups to band together and sue over a common problem, and the Administrative Procedure Act, a federal law that permits courts to set aside federal agency actions that violate the law, including rules, regulations, and memos laying out new procedures. Hours later, U.S. District Judge John Bates, a George W. Bush appointee, ordered federal health officials to restore hundreds of web pages containing gender-related data that officials took down pursuant to a Trump executive order cracking down on gender ideology. He described the move as an example of federal officials acting first and thinking later. And in Massachusetts, Reagan-appointed U.S. District Judge William Young was careful to emphasize that his expansive ruling restoring health research grants, cut following the same executive order cited by Bates, was nonetheless tailored only to provide relief to the organizations that sued. Like Bates, Young's ruling relied on the APA. Quote, public officials, in their haste to appease the executive, simply moved too fast and broke things, Judge Young wrote. In short, the Supreme Court's ruling on nationwide injunctions may be the tectonic shift that wasn't. Despite the extraordinary potential to reshape the judiciary, its immediate impact particularly in the innumerable challenges to Trump's effort to single-handedly slash and reshape the federal government, may be limited. And friends, before we talk about the implications of so many federal court judges still pushing back against Donald Trump's lawlessness, even in the aftermath of that new horrific Supreme Court ruling, let me touch on one more legal development. This headline from the AP, federal judge blocks Trump administration from ending temporary legal status for many Haitians. And that article begins, a federal judge in New York on Tuesday blocked the Trump administration from ending temporary legal status for more than 500,000, 500,000 Haitians who are already in the United States. District Court Judge Brian M. Coogan in New York ruled that moving up the expiration of the temporary protected status, or TPS, by at least 5 months for Haitians, some of whom have lived in the U.S. for more than a decade, is unlawful. The Biden administration had extended Haiti's TPS status through at least February 3rd, 2026, due to gang violence, political unrest, and a major earthquake in 2021, and several other factors, according to court documents. The ruling comes as President Donald Trump works to end protections and programs for immigrants as part of his mass deportations promises. The judge's 23-page opinion states that the Department of Homeland Security's move to terminate the legal protections early violates the TPS statute that requires a certain amount of notice before reconsidering a designation. Quote, when the government confers a benefit over a fixed period of time, a beneficiary can reasonably expect to receive that benefit at least until the end of that fixed period, according to the judge's ruling. The judge also referenced the fact that the plaintiffs have started jobs, enrolled in schools, and begun receiving medical treatment with the expectations that the country's TPS designation would run through the end of the year. So, friends, even with the Supreme Court's idiotic and horrific ban on nationwide injunctions, the federal judges still have legal tools to reject, to rule against Donald Trump's lawlessness and unconstitutionality. And why do I say the Supreme Court decision on nationwide injunctions is idiotic and horrific? Because here is what it boils down to. A litigant came into court and she proved that something Donald Trump did would violate her constitutional rights, proved it to the satisfaction of a federal judge, and that judge issued a preliminary injunction and said, well, this clearly violates constitutional rights, so it should have nationwide effect. And the Supreme Court said, no. I mean, that litigant, that plaintiff has her rights protected, but what? Donald Trump can violate everybody else's constitutional rights, unless they have the money to hire a lawyer and file a lawsuit themselves, or unless they can join a class action suit, or a class is certified that might include them. No. Otherwise, Donald Trump gets to violate everybody else's constitutional rights until they can, find the right attorney and pay the right amount of money to have their constitutional rights protected. Are you effing kidding me? That's why we need nationwide injunctions, to prevent this sort of runaway lawlessness and unconstitutionality. Put a preliminary stop to it while the case gets litigated through the courts. That's why I say it's idiotic and it's horrific. But the federal court judges apparently will not allow Donald Trump's lawlessness to go unaddressed. And what we are seeing now in the aftermath of the Supreme Court essentially restricting, if not banning, nationwide injunctions altogether, well, the federal court judges are saying, if not a nationwide injunction, then a class action to protect people's rights, including their constitutional rights. And if not a class action, well, then we'll use the Administrative Procedure Act, the APA, to protect people's rights. Because to those federal judges, like to us, justice matters. Friends, as always, please stay safe. Please stay tuned. Happy upcoming Independence Day, and I look forward to talking with you all again tomorrow.